Thank you so much. So, good morning, everyone. I welcome you all, and I hope you all are doing well. So, for day 4 of this program, we are going to have 4 sessions today. For this first session of day 4 of this capacity building program, so we have with us Mr. Ankit Kaushik, who is going to discuss on Packer's two models of criminal process and beyond that. Mr. Ankit is an assistant professor of law at the Rajiv Gandhi National University of Law. He is also a faculty coordinator of the Center for Criminology, Criminal Justice and Victimology at RGNUL. Now, without wasting any further time, I request you to address all of us.
Okay, thank you so much, Amit. All right, so good morning to everyone. I believe it's let's say a very lazy morning because it's winters out here, and I'm pretty sure I'll just have to shake you all out of your slumber, right? So I hope this lecture is able to do that with you all, right? I'll take over from what Professor Tom Ellis was speaking about yesterday when he was talking about the crime control values and the due process values that can be found in our criminal justice systems across the world. So he specifically discussed it in the context of UK, but and for the majority of my lecture today, I'll be going beyond Packer's two models. But just to give a brief background about the main topic of the session, which pertains to going beyond Packer's two models, I'll summarize what Packer has forwarded in his piece. So these two models, the crime control model and the due process model, this was forwarded by Herbert Packer nearly 67 years ago in his very seminal piece about about titled "The Two Models of Criminal Process." His piece is one of the first academic writings to study the criminal process with a very academic and a juristic rigor. Right before this piece, the focus of most academic literature had been upon substantive law. It was about criminalization of conduct. It was about moral wrongs, legal wrongs. It was about the theories of punishment. What are the justifications for punishment? And this was pretty much the purview of what most scholars dealt with when they were dealing with substantive, when they were dealing with literature on criminal law. But this was a pioneering piece in that this piece sought to examine the jurisprudential foundations of the criminal process. Now, this piece has inspired a complete generation of scholars, and it is so relevant till date that we have had to schedule lectures to learn about this writing in this capacity building course itself. Now, this is a testament to Packer's very insightful and keen observations and the theoretical affirmations of what we Indians we already know to a very large extent, and we know it very instinctively. And this is that the more we learn about the is of our criminal process, the more we become aware about what ought to be. Right? In Packer's words, the greater the knowledge of the two, the greater the gulf is between the is and the ought. Let's take the case of Adam Bhai Suleiman Bhai Ajmeri. Now, in the aftermath of the Akshardham terror attack case in Gujarat, which occurred in 2002, it led to the death of nearly 35 persons and more than 100 persons were injured. The Gujarat police, it went on an arresting spree. They detained and charge sheeted almost the 6 accused. Now, these accused, they were convicted by the Sessions Court, they were convicted by the High Court, but they were all acquitted by the Supreme Court, and this ordeal for them lasted nearly a decade. One of the most crucial pieces of evidence that was produced in the case was a letter that had purportedly been recovered from the pockets of one of the dead terrorists. And this letter named all of the 6 accused. The Supreme Court in its judgment observes that it seems rather incredible that letter was recovered from the pocket of the dead terrorist did not even have a single crease on it. The Supreme Court also found that it was incredible that the letter did not even have a single blood stain on it despite the fact that the terrorist had been gunned down by a barrage of bullets. Can we imagine this situation where a A4 size piece of paper can be kept in somebody's pocket without a fold, without a single fold? Or can we imagine that there is a dead terrorist covered with blood, but there is not a single drop of blood on that note that is recovered? It's pristine. Now, when one of the accused was finally acquitted, he agreed to narrate his ordeal. He pleaded like he had pleaded from the start that he was innocent, but he was tortured and and upon it when he refused to sign a confessional statement, that led to worse excesses. In one instance, he recalls that a police officer had literally offered him three cases, right? The first case was that of Godra Kand. The second case was that of the murder of Haren Pandya. And the third case was about, just give me just 1 second, please. All right, sorry. Yeah, and the third case was the Akshardham terror attack case. And he was literally offered and asked, which of these three cases would you like to be implicated in? Can you imagine? It's like you're going to a restaurant and you're ordering off a menu. Like, do you want to be implicated in this case? Do you want to be implicated in case number one, case number two, case number three? And this is the is of our criminal justice system. This case is riddled with so many procedural irregularities, whether it's at the stage of arrest or it's at the stage of investigation or it's at the stage of trial. Um, but I won't be going into these aspects of these irregularities. That lecture is scheduled for tomorrow. It'll be taken up by Mr. Neeraj Tiwari. And this will focus on all of these aspects, all of these procedural irregularities, and how we can critique the criminal process and in much greater detail. But if one is to normatively critique how the criminal justice system went about its business, I would say one can hardly find a better example than the Adam Bhai Adam Bhai case. Uh, Now, this is a very prime example of the difference between the is and the ought of our criminal justice system. And this is the difference which irks Packer. Now, in his piece, Packer asks us to, force ourselves to detach detach ourselves from our value choices, from our value systems, and to, maybe examine the two models that he has forward in a very objective manner. He tells us that the kind of criminal process we have, it will largely depend on the underlying values that the system, reflects in its functioning. It can that those values can be reflected directly, or those values can also be reflected indirectly. Now, in identifying these values of the criminal process, he then describes the two models of criminal process. Um, the first model is that of crime control. The moot function of the crime control model is repression of criminal conduct. It is based on the idea that we can quantitatively analyze if a criminal justice process is successful or not. What this means is that a high rate of failure to apprehend or a high rate of failure to convict can potentially lead to public disorder. In this sense, much in line with the theory of social contract, which is proffered by Hobbes, Locke, and Rousseau, the purpose of criminal law then becomes to guarantee, the liberty and to guarantee that the rights of individuals are protected against the transgressions of others. Now, to do this, the criminal justice system only needs to focus on the efficiency of the investigation, trial, and convictions as per the crime control model. Now, efficiency, again, in this sense, refers to the capacity of the system to try to, apprehend and convict as many individuals as it possibly can. This model necessarily, therefore, needs to produce a very high rate of apprehension and a very high rate of conviction if it is to be considered as successful. But if we are to achieve this kind of efficiency, then we need two further characteristics. We need the characteristic of speed and we need the characteristic of finality. Speed can be attained through, let's say, bringing a sense of informality into the system. And what this informality means is that we can have some extrajudicial processes which can be given a greater weightage over formality. For example, under this model, we can maybe allow for confessions that are extracted at the police station as admissible in evidence, right? Uh, Uniformity, however, requires that the entire criminal process must look like a factory or an assembly line or a conveyor belt. Now, each stage is like a factory. Each stage is like a factory line, right? And you have the, for example, the pre-arrest stage, then you have the arrest stage, then you have the post-arrest investigation stage. You have the preparation for the trial, you have the trial, you have the conviction, you have the sentencing, and each of these stages is performed by a specific set of persons who are so specialized in their task that specialization itself will bring in a measure of efficiency into the system. Now, at the same time, I would say that Packer does not actually say that the crime control model cannot have rules which forbid the use of illegal arrests or forbid the use of forced of unreasonable searches or of using coercive techniques during investigation, but that these rules, they cannot stand in the way of efficiency. And what this means is that a conviction cannot be reversed merely because there is a procedural irregularity. Like there was an illegal arrest, that does not mean that the person will be let go or that accused can be let off. Um, the second extreme of the criminal justice system, the second pole of the criminal justice system, of the criminal, as per Packer, has been termed as the due process model. Now, this model essentially looks like an obstacle course, or it looks like a hurdle race. Now, every stage of this process is designed in a manner that the accused is given an opportunity to prove his innocence. So, if the police commits a mistake, then the prosecution can correct it. And if the prosecution commits a mistake, then the court can correct it. And if the court commits a mistake, then the appellate court can correct it. Now, Packer says that much like the crime control model, uh, the due process model also wants to repress crime, but it is suspicious of the methodology that has been adopted by the implementers of the crime control model. As opposed to speed and finality, this model of due process, it focuses more on reliability. Due process, it seeks to be efficient, but not at the cost of reliability. So Packer says that it resembles a factory which believes in quality control. So even if the factory is not producing too many goods, all of the goods that are being produced, they're of the highest quality. Now, uh, in its concern for reliability, the due process values are grounded in the concept of individual rights. They're grounded in the concept of libertarian values which support them. In this conceptualization, a very great weight is attached to the effects of criminal sanction. You know, when a criminal sanction is imposed, it leads to a loss of liberty. It leads to a stigma getting attached to that conviction. And, you know, criminal law and the processes of criminal law, they're the extent of the state's coercive powers. They are the final end of the state's coercive power. And therefore, the due process model wants that we must have the greatest control and safeguards when it comes to imposition of criminal sanction. Uh, so what I've just stated here is an extremely compressed version of Packer's models. And there is a lot more to these models that I can possibly expound in the course of this lecture today. Scholars, like I said earlier, they have been building upon his work for more than 7 decades now. And if we are to study Packer, comprehensively, then we'll probably have to have a separate subject on the same introduced in our courses. Now, so in a way, we can say that we are second generation scholars to be inspired by seminal work. And as the requirements of intergenerational progress dictate, we must carry forward his work. We must examine it critically, and we must see how we can better these two models which have been proposed by him. What are the pressure points in this model, and what are the contradictions that we have to resolve? Uh, in the orientation session, I remember that Professor Bajpai, he had quoted a very pertinent statement by Morton Horwitz, which I am inclined to reiterate at the moment. It states that the underlying structure of law remains that of forcing the students to reconcile contradictions that cannot be reconciled. I think that this statement, it very beautifully encapsulates the underlying purpose of this capacity building program. And it is this thought which brings us to the topic of my talk today, which is going beyond Packer's two models. Uh, the purpose of this talk is to introduce you to the work that has been done by a few of these scholars and how they highlight some of these contradictions. One of the readings that has been shared with you is Kent Roach's Four Models of Criminal Process. So, in this work, Kent Roach analyzes Packer's two models of criminal process and concludes that both of these models, they completely miss out on a very important stakeholder of our criminal justice system. Both the crime control and the due process models identify the roles of the police, they identify the roles of the prosecutor, the judges, and the accused. And howsoever different they may be with respect to delineating these rules, and howsoever different they may be with respect to the extent of these roles, but both these models have it in common that they fail to speak about the victims, and more specifically, the role of the victims in the criminal process. So Kent Roach tells us that the measure of efficiency that Packer thinks the crime control model brings to the table, it completely disregards the fact that most victimization studies today reveal that a majority of the crime goes unreported. And where crime goes unreported, the system can hardly be called as efficient. On the other hand, criticizing the due process model, Kent Roach points out that that Packer wrote his piece much before these victimization studies and the feminist scholarship and the critical legal scholarship. They were able to document that the majority of the victimization which occurs in the society is amongst the most marginalized and vulnerable sections of the society. So even if Packer's due process model assumes that the rights which are accrued to the accused by virtue of the due process model, they would be protected, yes, even if the accused is disadvantaged. But uh, Packer seems to completely miss out on the fact that even the victims can be disadvantaged. They too can belong to the marginalized sections of the society, and therefore they do not have equal access to the law or the protection of the law. From here, we can see the first glimpses in our talks emerging of a victimological critique of criminal law. Right? The capacity building program, it would have been incomplete if we were to keep victims out of the loop. And so we'll be circling back to the models that Kent Roach has proffers as a remedy to remedy the lacuna in Packer's models. But before we do that, I think it's very pertinent for us to relate what has just been said to our own criminal justice system. To enable our understanding in a more nuanced way, I will very quickly sum up the extent of victim participation in our own criminal justice system. To begin with, we have Section 24, Clause 8 of the Code of Criminal Procedure, the proviso to which allows for the victims to hire their own private counsel to assist the prosecution, right? But this section is still silent as to what is the extent of this assistance. Um, the extent of this participation in turn has to be gauged from Section 301 and Section 302 of the CRPC. Under Section 301, the prosecution before a court has been before a court of sessions, sorry, has been discussed. Now, it says that the public prosecutor or the assistant public prosecutor can appear before a court of inquiry, trial, or appeal. Subsection 2 of Section 301, it states that where a pleader is instructed by a private person or the victim to prosecute any person, then the prosecution shall still be conducted by the public prosecutor. And the victim's private counsel can, with the permission of the court, submit written arguments only after the evidence has been closed in the matter. So Section 301 effectively, it creates a bar as regards private prosecution in a court of sessions. The point of law is reaffirmed by a reference to Section 225 of the CRPC, according to which the trial before a court of session can only be conducted by a public prosecutor. The victim, therefore, is left with a very restricted right to participation. So the victim can only submit written arguments after the evidence has been closed in the matter. He has no right, for example, to cross-examination or for calling witnesses or of calling evidence. He can, at best, he can file an application under Section 311 to summon material witnesses or to summon documents, but that is not a matter of right. That is at the discretion of the court. Um, so this is the situation for the Court of Sessions. It's slightly better when it comes to the magistrate court, because Section 302 states that the magistrate who inquires or tries a case may permit the prosecution by any person except the police officer below the rank of inspector. So in a magistrate's court, yes, the victim may be given the opportunity to conduct private prosecution, but again, this is not a matter of right. This has to be done with the permission of the magistrate. Apart from this, we have a sprinkling of other rights, right? It just here and there, some enabling provisions maybe. For example, the victim has a right to file a protest petition. That's not written anywhere in the Code of Criminal Procedure. That's just a matter of practice, right? Or the victim can ask for compensation under Section 357A. That has its own set of problems. Or Section 357, which is not being applied in practice. And again, like I mentioned, we have Section 311, under which the victim can maybe file an application to the court asking for the court to summon material witnesses. But by and large, the victims have a very, very limited and a very restricted right to participation in the criminal justice system. Uh, Now, this brings me back to the article which was mentioned by Mr. Sanjay Vashisht in the panel discussion on the law relating to arrests and detention, where he referred to Niels Christie and his seminal piece titled Conflicts as Property. This is also a part of your reading. It has already been supplied to you as well. But the basic idea behind Niels Christie's writing is that criminology and criminal law, it has amplified a process where the conflicts have been taken away from the parties who are directly involved, and thereby they have disappeared completely, or they have become other people's property. So they've become the state's property. Conflicts are a property which belonged to the accused and to the victim, but with respect to the victim, that property has now been taken away by the state. In particular, Christie argues that the victim is a very heavy loser, attributable to not only a material loss in terms of the physical injury that he suffers, but also in terms of the loss of his status as a participant in his own case. Now, this is prominently characteristic of adversarial systems. In this jurisprudence, in our jurisprudence, a crime is often defined as an offense against the society at large. The state takes over the functions of investigation, they take over the functions of prosecution and the execution of the sentence as well. To uphold the due process of the law, the offending accused is given a fair amount of protection. He's given a fair amount of rights against the state. But the victim, they just come to be treated as another piece of evidence. They just become a testimonial witness. They just become a stage prop, a theatrical aid in the larger scheme of things. And this entire exercise, it translates into evidence that securing justice to victims is not the prerogative of the state, but securing justice to society is. The state, it fails the victims twice. It fails the victims first because it fails to prevent the offense in the first place. And second, it fails to restore the victim to their rightful possession, both in terms of the material loss that is suffered by them as well as their participation. But beginning in the late 20th century, much has been written from a victimological perspective about the removal of this injustice. Nevertheless, much of what has been written about this injustice to victims, it is yet to translate into laws or even an official policy on part of the state, right? And at least this is especially true, or at least this is true in the Indian context. Uh, if we still have a very limited participation for victims in the 21st century, we can hardly blame Packer for not including them in his models, right? But moving on from Packer also requires a lot of introspection on our part, right? The discourse on on victim jurisprudence was still at a at very early stages then, and most discussions on victim justice come fairly late in this chronology. Um, so the lacunae in Packer's models, so these have been addressed in 3 of the readings which have been sent to you. The first reading is by Leslie Seba. It's titled Victim's Role in the Penal Process. In the context of the 1980s, that's when Seba wrote this piece. Seba laments that the reform in legislative frameworks, they have only concentrated upon improving, one, the material situation of the victim, and two, the removing the psychological trauma that is suffered by the victims. He finds that most of the academic discourse on this issue has also not focused upon two very important aspects of criminology. The first being the exercise of the discretion of the police, of the prosecution, and secondly, what is the role of criminal and civil actions working in combination with each other. So we are again talking about the alternative dispute resolutions in criminal law. There is no discussion happening on that yet. We are not talking about restorative justice yet. In continuation of the tradition of making models, which was started by Packer, Seba also formulated 2 models of victim participation. The first model is the adversary retribution model, and the second model is the social defense welfare model. But at the same time, he says that these 2 formulations, they differ very significantly from what Packer has says, and they differ in 2 very significant ways. The first way is that that Packer's model do not take into consideration what is the theory of punishment, uh, because the theory of punishment also dictates to a large extent what kind of criminal process you need. Second was that Packer's model, they highlight the relationship between the state and the defendant without taking into account the victim's role in the penal process. So coming to his first model, the adversary retribution model, uh, like the name suggests, it is a logical conclusion to the adversarial tradition. This model, it focuses on staging a very direct confrontation between the accused and the victim. It concentrates on increasing the role of the victim in the trial and the sentencing stages of the penal process. It also very greatly enhances the role of the victim in not only the prosecution of the offense, but in arriving at the commensurate sentence as well. The state, it limits its role to the role of an, let's say, a overseer. So they're basically an enforcer of rules, but they're acting primarily on behalf of the victim. They, so in order to enable the victim to prosecute efficiently, the state provides legal aid to the victims. They also provide them with access to information as regards the criminal justice system, right? Uh, Allowing for private prosecutions also helps in this regard, right? So in other words, the state provides the entire machinery for the victim to achieve whatever objective that the victim has, whether it is prosecution or if it is compensation restitution. Uh, Under the adversary retribution model, the victim gets all the assistance from the state with respect to access to justice. They get legal aid, they get information in order to ensure whatever is the outcome of of their choice. Right? The underlying theory of punishment in this model, it still remains retributive, however. This is not talking about reformation of the accused. This is not talking about rehabilitation for the accused. The underlying theory is still retribution. It is meant to reflect the debt which is owed by the offender to the victim, and all the resources of the state are geared towards achieving this purpose. Right? The second model, which has been proffered by SEBA, is the social defense welfare model. This model is much better suited to inquisitorial systems, and it aims to eliminate any kind of direct confrontation between the victim and the offender. Uh, this model, it proceeds on very utilitarian considerations, and the stress is laid upon controlling the offender in terms of his threat to the society. Now, this can be achieved either through rehabilitation, or it can also be achieved through incarceration. But even this incarceration, uh, the underlying theory of punishment remains reformation. Right? At the same time, it seeks to address the needs of the victims in terms of creative restitution, which includes the rehabilitation of the victim. The role of the state is to provide services to the victims for assuaging the distress in which the victim finds themselves. Right? So the point is to minimize the harm that has been caused to them after the offense has occurred. This can be achieved by providing for the victim's loss through a system of state-sponsored compensation, regardless of the accused capacity to pay. Therefore, in terms of the compensation, the state put themselves in the shoes of the accused, and not only the shoes of the victim, as it is in traditional adversarial systems. The victim does not have a direct claim against the offender. The victim has a claim against the state. This also opens up a possibility of civil action in conjunction to criminal action. Prosecution is the prerogative of the state, but the victim has a right to appeal against non-prosecution. So even in the most, let's say, the least participative model by Leslie Sebag, the victim still has a right to appeal against non-prosecution. Conversely, the social defense model, also welfare model, it also focuses on the principles of compensation and assistance, and aims to remove the confrontation between the victim and the accused completely. The state gives compensation to the victim and not the offender, right? All right. Now this brings us to the second reading by Douglas Balloof. This is titled The Third Model of Criminal Process. So Douglas Balloof only offers one single model, but his model is essentially a thought belief or a belief in and of itself. Uh, he challenges Packer's understanding of the criminal justice system in the sense that while Packer only focused on two of the models existing on a vertical plane, right? All of your stages are on a vertical plane. They go from bottom to top. But Balloof says that we should also consider that there might be a horizontal axis to this as well, right? So Balloof agrees with Leslie Seba that there is a need to introduce victims into Packer's models. Instead, he recommends a third model, that of victim participation, so that victim participation can be across all stages on that vertical plane, right? Except that this is now horizontal in nature. So that victim participation can go from one end to the other end, depending on the kind of system that you want. But at the same time, it's going to be there throughout the entire criminal process. So he deploys Packer's terminology, and he talks about the application of values which underlie the victim participation model, right? He identifies these values as that of fairness to the victim, respect for the victim, and dignity of the victim. All of these values, they translate into certain rights of the victims which resemble the due process values, but for the victims. The primacy of the individual victim is the underlying value, right? According to Balloof, the fundamental justification for providing due process like rights to participation, it's to prevent the victim from suffering two kinds of harms. Right? The first is the primary harm, which results from the crime itself, and the second is the secondary harm, which occurs from the governmental processes, right, and from the governmental actors within those processes. Now, this value is derived from the prospect of primary harm taken together with the concept of minimizing secondary harm to the victim. The value of primacy of the individual, again, I will reiterate, the value of the primacy of the individual victim is what is at the heart of the model of victim participation. Right? We can come now to the third reading, which has been prescribed to you, and it's by Kent Roach. I've already mentioned this before. He wrote the 4 models of criminal process. So in this writing, uh, Roach acknowledges that Packer wrote his piece before the victimization studies could document that there is a very large prevalence of underreporting of offenses. These studies, they also challenge the prevailing understanding of crime control activities of the police and the prosecutors are represented as the entire data set of actual crimes being committed, right? This high rate of reporting, it can be considered as a sign, high rate of underreporting can be considered as a sign that the criminal justice system has failed and is insensitive to the needs of a large number of victims, particularly from the marginalized and vulnerable sections of the society. Um, he goes on to introduce the 2 models of victim rights. Right? The first is a punitive model of victim rights and a non-punitive model of victim rights. Much like the crime control and the due process models, both of these models, they represent 2 extremes of victim participation in a trial. The punitive model, uh, Kent Roach says that it has to be understood as a roller coaster, right? Compare this to what Packer said earlier. Packer said that the crime control model resembles a factory. You know, the due process model resembles a factory with a focus on quality control. But then Kent Roach says that his punitive model of victim rights, it resembles a roller coaster. What this means is that much like the crime control process, crime under the crime control model, the entire criminal process, it proceeds on very expected lines. It goes from investigation to prosecution to punishment, but that this ride is now a little bumpier. This is not just a conveyor belt, this is an entire roller coaster. There are ups and downs because we have a better understanding of the failure of criminal sanction in controlling crimes, and that we have a better understanding that we need more rights for victims, and that there is a newfound respect now for the victims. So this model, it combines elements of both the crime control and the due process model. It puts pressure on the criminal justice system to identify and correct what is wrong with it, to encourage victims to come forward and report the offense, and to ensure that there is no secondary victimization as well. Now, victims are given a Bill of Rights, and these rights are very comparable to the rights of the accused. They have the same status constitutionally and legislatively as the rights of the accused do. Now, this model is sort of similar to the crime control model because this too assumes that enactment of criminal law, that prosecution and punishment, it helps in controlling crime. Right? But the role of the police in the prosecution, this is not as central anymore. For kickstarting that process and or even at the initial stages, the crime control model focuses on investigation. If the police says that the accused is probably guilty, then he'll be passed along to the next stage, and the next stage will assume that he's probably guilty. But under this system, the police is not given as much importance. Um, the work of the police and the prosecutors, it's placed under constant scrutiny by the victim and as well as the guilt of the offenders. So Roach proffers that this system would then create a class of professionals, victim advocates, who are so overzealous in their work that they favor more and more criminal sanctions, because more criminal sanctions means that more and more victims also get recognition. Now, they're often very, let's say, against the due process for the accused, but only because they want due process for the victim. So the efficiency, therefore, of this model is so compromised that both the prosecutor and the accused, they're encouraged by the inefficiency of this model to agree to a guilty plea, right? The second model, which has been proffered by Kent Roach, is that of the non-punitive model. So unlike the bumpy ride of a roller coaster, which goes from one end to the other, uh, this can be understood as a very smooth circle, a circle which symbolizes crime prevention and which symbolizes restorative justice. He gives two examples in which this circle manifests before a crime has occurred. One is a example of a gated community with its own private police, and the other is a very close-knit community with neighborhood watches and self-policing. So after a crime occurs, this circle then represents the process of restoration, including the healing and compensation to the victim. The purpose is to minimize the pain of inconvenience, the pain of victimization that has been caused to the victim. And at the same time, the purpose is to minimize punishment as well. Now, these might seem counterintuitive, but they don't often have to be. Roach proffers that one explanation why victimization surveys they show that there is a high rate of prevalence of unreported crimes. It's because the victims look at ways other than the criminal justice system to heal and recover. So they don't always want the criminal justice system to intervene on their behalf, or they don't always go to the criminal justice system because they believe that they themselves can also heal, they can also recover in a better way. So unlike the punitive model, if a victim does not want to invoke the criminal justice system, then his wishes must be respected. So this model is very similar to the due process model because it shares doubts that criminal sanctions might just be overrated, and that we might just be attaching more importance to criminal sanctions than they actually deserve. Uh, the value of crime prevention, it can be achieved through the identification of those who are at risk, right? This can be done through risk analysis, or this can be done through situational crime prevention, amongst a gamut of other measures as well. These interventions that follow the risk analysis, they're not just for victims, they can also be for accused as well, for those who may potentially commit crimes. Like, for example, early childhood interventions where they think that the child's behavior is let's say disruptive or it's antisocial, then an intervention at an early stage can maybe ensure that such behavior does not culminate into criminal behavior at a later stage in their life. Or, for example, bettering the parenting skills of parents. So this is something that the community can do at their level itself. We have but these strategies, they work at a longer time scale, but we can have better immediate strategies as well. For example, we can just have better lighting on our streets. Streets which are well lit, they are less likely to have crimes committed on them. So, but all of this is before a crime is committed. Under this model, all of this measures that I've talked about, they're about crime prevention. But that is one part of this model. The other part of this model is about restorative justice. So once a crime is committed, the focus then shifts to minimizing the harm which has been caused by the offense. And ultimately, the ultimate aim, it's to restore the victims to their earlier position. The offender there's subjected to a process where he owns up to responsibility, where he attempts to repair what harm he has caused. And all of this is done without the intervention of the criminal justice system at all. So I can see that it's already 10:46. So I'll stop here. I'll stop here now with a parting thought, that while we have only referred to 3 readings for the purpose of this course, there are many more models of victim participation out there. Like, even here, none of the models that I've discussed should be considered to be absolute models, right? So much like Packer's models, all of these models, they're not incongruent with one another. Uh, in my opinion, they're not as mutually exclusive as they seem at the first glance. Uh, the present legal system, they can be strengthened through an incorporation of those features and And indeed, we can choose what features we want from these models, and we can come up with our own model of victim participation. And this is what is required to be done for our criminal justice system to ensure that we have an effective and efficient victim participation in our system. So we must strive for greater victim participation. In the case of Mallikarjun Kodagili, the Supreme Court had made a reference to victim impact statement. The entire point of having victim impact statements is to ensure that the victims get a say in the criminal process. How this victim impact statement is used will differ from jurisdiction to jurisdiction. But the entire point is that maybe at the stage of sentencing, for example, if the court has in front of it the impact of the crime upon the victim, it might be in a better position to judge what kind of punishment should be given to the offender. Um, in a very case of where Professor Bajpai was an amicus curiae, and we were part of a research team that had drafted the report. The Delhi High Court, they laid down a very detailed procedure regarding the application of Section 357. Now, this provision has been on our statute books for decades, but it has been a dead letter. It has hardly been applied in practice. Now, simply because our judges, they lack a procedural framework to be able to implement, uh, Section 357. They don't know how to calculate the fine that the accused must be asked to pay. And there is no provision which states that you must also take into account the harm that has been suffered by the victim in the calculation of the fine. So this has deterred the judges from using this section, which is meant for the betterment and the benefit of victims. So understanding these models, getting in, like building an understanding of how we can get or ensure greater participation in the system. Um, these models can help us in remedying this problem, right? So with this, I now yield the floor to Amit. Amit, can you take over, please?
Yes, sir. Thank you so much, sir. Thank you so much for your insightful thoughts on the topic. And now this floor is open for discussion. And whoever is willing to participate, please raise your hand. Yes, Achint, please go ahead.
Yeah, very good morning, sir. As I was hearing the discussion, uh, I had this very strong sense of that maybe if we also take this topic and place it in the domain of law and economics, maybe we'll be able to find a lot of better answers. And as you just said, that at a lot of times judges also face difficulties in how they are to calculate the amount of compensation, plus also the need to arrive at an efficient system. So I think all those can be addressed better when we delve into the domain of law and economics, and with the help of economists or with the help of application of some economic systems, we can derive a better way to deal with such problems.
I completely agree with you there, Achintya, because so being able to come up with a calculator, what are the considerations that have to be taken into account, right? What are the kinds, for example, to be able to quantify the harm that has been suffered by the victim physically. Like, I'm not just talking now about the loss of their earnings, right, because of the hospitalization that was required, right? So that can translate directly into a figure. But I'm also talking about some of the more immaterial or intangible damages. What about psychological harm? How do you take that into account? So all of this has to be, like we need to develop some kind of quantifiable mechanisms for judging what is the amount that is required to be paid to compensate the victims or to restitute the victims in this regard. Yeah. So therefore, yes, we can definitely use the field of economics to be able to help to, judge what is the amount required.
Okay. Dr. Kalpana, ma'am. Kalpana, ma'am, can you hear me?
Can you hear me?
Yes, ma'am. Now I can hear you.
Uh,
Yes.
something came to my mind when I was listening you, Ankit. There had been lot of instances, cases of rape charges, where victim of rape is offered a marriage proposal by village panchayats and sometime from the family of that rape offender. Though we all know rape is not compoundable offense in IPC, when the case is referred to court, court cannot legitimize rape on a marriage proposal. So I'm just taking a case where actually offender is having sense of guilt after getting it over. Such kind of sense of guilt can be a considerate factor to. I'm not saying rape can be legitimized. I'm talking about as an alternative in such cases, which we perceive it as one of the most heinous crime, and it is having zero tolerance sort of aspect in all of the societies. So, how do you look at such cases where I'm talking about sincerely offender is having a sense of guilt after doing that?
Okay, so that's a very, very good point to raise, Dr. Kalpana. Uh, the so in one of my researches that I was working on a very major research project. It was on status of crimes against women in northern regions of India. So I had gone to Jabalpur for my field work and for collection of data. There I met a district judge, a special judge, who was taking POXO cases, like who was hearing cases on POXO matters. And while in the course of the interview, uh, I asked her this exact aspect, and she said that we have, as judges, we have to take into consideration those societal factors, and we have to take into consideration the future of the victim as well. And where both the parties are ready to do it, we often let the accused go in rape cases as well. But then I said that okay, but the Supreme Court has very specifically said that rape is not a compoundable offense, and you cannot just let the accused go simply because he has offered to rape. If that is the case, then and all an accused has to do is to rape a person to get married to them, right? And she just said that we understand that the Supreme Court has said this, but all we need to do is to dilute the evidence. And this is coming from a judge, mind you. This is not a village panchayat, like you said. So if this is the value that underlies our system, then this is bound to spill over into other aspects of our system as well. So I do not condone this at all. If at all the accused is guilty and they have a sense of guilt and they're ready to own up to the guilt, they're ready to own up to what they've done. In that case, they still have to do that within the bounds of the law, right? It can at best act as a mitigating factor for the judge at the time of sentencing. They can maybe get a lighter sentence, but at the same time, they should get that sentence.
Actually, law does not permit such things. I'm
Yes, it does not.
about where a victim of rape be a pregnant woman, maybe a minor. So, looking into the situation, because punishing an offender and sending him jail would not bring justice to her. I am not saying ke be happy and get married to a rape offender, but in case there is a sense of guilt and a person is actually looking for an apology and trying to own up his guilt and ready to, no, be a change person. Though I am a woman, I do not advocate such theories, but you are right. I have come across such instances where court is looking into mediation कि ये किसी तरह से हो जाए. जब वो देखते हैं कि case is genuine and both the families are agreed upon it. So do you look it as an alternative restorative sort of mechanism in such cases?
Uh, so I do believe that there are ways to resolve this, like these differences that occur. right? What you're talking about here is, if these are called, there's a technique called family conferencing, and this is applied in several states in the United States as well, where if the, especially if the victims are minors, because the juvenile justice system is a little more lenient than the, the rest of the criminal justice system. So especially in those cases, if the victim and the accused, they can come to some kind of I won't say a settlement, but they can come to some kind of an understanding, then yes, maybe that can be taken into consideration. But again, that has to be done with the permission of the Juvenile Justice Board, at least in the Indian context.
All right, sir. So owing to time constraint, I think if you permit,
Thank you so much.
so if you permit, sir, then we will take one more question.
Please.
Okay. Mr. Udit Raj.
Thank you. Mr. Ankit, wonderful session. I was just, curious to, find out that, in our criminal justice system, hostility of witness is one of the, very important factors which takes away the spirit of the very criminal justice system. And it's a very curious case of a witness that he's sometimes neither the victim nor the perpetrator, but ends up becoming the victim of the criminal justice system. Any of the models of criminal process address about witness, or maybe witness protection or hostility of witness. I was just curious about that in case you found anything.
Yes, well, in my researches, I won't say there's a model on this, because most of the models, they focus on victims. But there are certain UN guidelines on how the the witnesses have to be taken into consideration. Also, if you read the procedure that has been laid out for witnesses in the UK, there also you can find that the witnesses, they're guided at every step. So they have a code there for this specific purpose. That the witnesses are told about what they can expect from the criminal justice system. They have a specific system to apply for witness protection. They have a system where, for example, if they don't want to be confronted by accused, then they have a system that maybe they should be brought in on another entry, right, from other than the entry from which the accused is coming, or maybe that they have to wait in separate waiting chambers other than where the accused is present. So all of these models can definitely be introduced in Indian context as well, to ensure that the witnesses are not put at a disadvantage. There have been a lot of cases on this as well. In the Indian Supreme Court has laid down guidelines in the case of Mahendra Chavla versus Union of India, in this context as well, where they essentially endorsed the witness protection scheme of the Delhi government as well. Right? So you can a reference. You can always have a reference to all of these.
Thank you.
Thank you, sir. Sir, actually, there is one more hand raised by Dr. Interpreet. So,
Yes. I think we can take more questions. Yes.
all right, sir.
Good
Thank you.
morning. Good
Good
morning.
morning.
Thank you for a nice session. I have one question regarding the compensation. As in
Yes.
in our country, there is a 357A, and as per that section, every state has to make a scheme. And but there is not a codified scheme, because in every state it is different from state to state. If the rape is committed in Punjab, the compensation is different, and it is committed in Goa, then it is different. So I want some comment on it, that what should be there.
Well, okay. So, the states are like, that is the federal structure of our criminal laws as well. Like, that heads out at what the Constitution says about this. So the states are the only ones who can actually come out with the schemes of their own. Uh, what the center can do at best is to maybe give a model compensation scheme, right? Encourage all of the states to adopt these model compensations for the sake of uniformity. But other than that, I don't think anything short of a constitutional amendment that can resolve this issue.
Because if you can see the case of Chandrima Das, there is a 10 lakhs compensation because that was an international, and in the other cases in the India, there is only 1.5 lakh, 2 lakh, 3 lakh. Like there's a major difference between the victim to victim is differ. If you can see the Rudal Shah case and the Bhim Singh case, Rudal Shah is getting only 35,000 for 14 years and Bhim Singh is getting 50,000 only for 2 days. So I want to do like to do some work on it.
That sounds like a brilliant idea to be beginning with, because the court literally does not have any, let's say, a standard by which they can gauge what kind of compensation has to be given. So that is why you see that disparity coming in from different courts, from different judgments of the Supreme Court, right? I would call this is a function of having different Supreme Courts at different points of time. So I think that is one dimension that you can always take into consideration, because when Justice Krishna Iyer came, that is when victim jurisprudence in India actually came to the fore. Before Justice Krishna Iyer, there was very little that was happening in the coming, or very few judgments from victims coming from the Constitutional Court. And after that, there was I won't say an explosion of, yes, there are some judgments that can also be referred to, but this is evolving over time. So this is a very interesting area of research. We should definitely take this up as well.
I think, Ankit, one more issue involved in this determination, why there is a variation in the compensation amount in most cases, in most states, because we have not really evolved a scale through which we can determine the quantum of compensation that should be awarded. So we actually, interestingly, I think I would draw your attention to one very interesting fact. What we gather from IPC when an offense is committed, we presume all the offenses are the same. However, these offenses become very different from case to case in terms of its impact on the victim of crime. So though the offense are the same, however, they have a differential impact. But there is no measure to determine this differential impact of crime on the victim. So, and unfortunately, we think that a crime causes a physical injury, but injury, definition of injury in IPC means, body, property, reputation, and mind, So these 4 dimensions. However, all the cases are decided to quantify the impact and compensation only in physical terms. The extent to which that offense has harm to the reputation of the person, to the property of the person, to the mind of the person, somehow that thing is not taken into consideration by the adjudicating court. Therefore, in other jurisdiction, they have worked out a very good criteria to determine the compensation that is called the victim impact statement. Now, victim impact statement is a tool through which we collect the data with regard to the differential impact suffered by the crime victim in physical and non-physical, both ways. And then thereafter, the compensation is determined. However, this task of determination is missing in our case. Probably the courts, but very recently in Karan, we have in Delhi, Karan versus NCT Delhi, the victim impact statement was accepted. And now, if we have to determine the compensation, probably we can look at some of the parameters. So I think this victim impact statement is available in public domain, and it is being extensively used in the US, in Canada, and Australia to take care of this particular parameter. However, in India, there is a small beginning in this direction. And that beginning has made some impact as far as the compensation determination is concerned. So probably the state will have to again rework as to how much they are providing to the victims of crime in terms of compensation. So I think this will take some time, but this process, as Ankit has pointed out, is very, very slowly getting matured in our country. Victim jurisprudence is evolving. So our lenses are different, but victim lenses are very different. So the moment we become victim-centric in our adjudication, in our determination, probably those things will be there for helping us in terms of deciding not only compensation, but also the quantum of sentence and various other things. So this is a small input to the otherwise a very brilliant discussion.
Thank you so
Yes.
much. Thank you so much for addressing the questions of the participants, and thank you for sparing out your valuable time. And thank you, participants, for participating during this discussion. Now we will take a break here, and there is a